to start the YouTube feed if you're ready.
And we are ready.
Okay.
Sue, if you could take your video down, it would be appreciated. We just want the task force members to have their video on. Well, good afternoon, everyone, and welcome to our meeting. And it's certainly nice to have you here. I appreciate you all attending the prior meetings that we've had. This is our third meeting of the task force. And we have a interesting program today, and I'm very appreciative to the vice chairman for organizing today's program. We will have the minutes from the last week's meeting, our in-person meeting, which was, I consider to be very successful. It was a great exchange of information from the perspective of a lawyer in the system who told us how the overall guardianship system works. And then we had a panel from the judiciary and a panel from clerks. Also, we had a good segment of public comments, and we certainly appreciated those public comments. Today, again, we're going to have public comments as part of our meeting. And Sarah Sanders, would you please go over how the public comments are going to work with our meeting? I'm going to ask everyone's indulgence as we do this because this is our first try with public comments through the Webex, and we hope we can get it done right. So, Sarah, please.
Let's see.
Thank you, Ken. Sorry about that pause. I just wanted to share a slide for everyone that's joining us via YouTube. So for today's virtual meeting and going forward for our next few virtual meetings.
There's 73 people on this thing today.
We will reserve the final portion of each meeting.
Submit verbal comments.
I'm sorry.
People
People are talking. If everyone could put their computer on mute, please hit the mute button.
So he's already like, he wants.
Unless you're ready to
does
talk.
not want to hear from people. He's such an asshole. He really is. He's already.
Hey, folks, somebody needs to mute owner. Somebody needs to mute the user owner, please. Thanks.
Wow, how indiscreet.
Well, we heard some indiscreet comments made. That's why we're asking everyone to please put their phone on mute, please. Sarah, public comment, please. You're going to tell us how this goes about.
Yes, thank you, Ken. Give me just a second. Sorry, I'm having some technical difficulties of my own.
Okay, well, I'll give you a chance to get through the technical difficulties. I'm going to call roll, so those members of the task force, would you please unmute yourself as I go through the roll call, okay? We have our Crystal Kinzel, clerk from Collier County. Are you present?
Yes, sir.
Good. JD Peacock, the clerk from Okaloosa County.
Yes, sir. Thank you, Ken.
The Honorable Jennifer Bradley, State Senator. The Honorable Colleen Burton from the Florida Legislature. The Honorable Sean Canigan.
I'm here. Good afternoon.
Thank you. The Honorable Jose Rodriguez. Is Judge Morley with us today? I know she's our special advisor. Okay. Sanja Brennan. I think I see you.
Good morning. Yes. Good afternoon. I'm here.
Michael Linton McCray.
Yes, I'm here. Thank you, sir.
Thank you. Anthony Palmieri. Anthony, I see you. I know you're here. We can't hear you though, Anthony. We couldn't hear you there, so you may want to check your mute button there. Gina Rossi Scheinman,
Present.
thank you. Nice to see you, and thank you for being with us today. We missed you. Tamara Cribben. Viviana Bonilla Lopez.
Here. Hi, morning, everyone.
Good morning. Hillary Hogue.
Here. Good morning, everyone.
Good morning. Dennis Moore. Zane Smith. Mike Donovan.
I'm here. It's afternoon where I am.
Okay. Shannon Mackenzie Miller.
I'm here. Thank you.
Is there a representative from Veteran Affairs here? Veteran Affairs, I thought I saw someone from Veteran Affairs. How about from the Department of Elder Affairs?
Hey, Clerk, Richard Prudhomme.
Hi, good to have you here with us. Welcome.
Thank you.
Certainly appreciate you being part of this task force. From the Attorney General's office, Karen Marullo.
Hi, good afternoon, Ken.
Thank you. Is there anyone who joined us who I didn't call their name and I missed? Okay, that's great. Thank you for being with us. Now we'll get back to the, go ahead, I'm sorry.
Clerk Burke, I see Representative Burton's hand up.
Oh, okay. Can we unmute her, or she's, Representative Burton, are you here with us?
I am here. I'm not going to video because I'm still home recuperating, but I wanted to let you all know I'm listening.
We're not going to be planning any dances, so you don't have to dance, Representative Burton. And I'm sure that's good news, you know, but I hope the surgery went real well for you.
Things are going very well. Thank you.
Good. And thank you for being part of this task force. And we did miss you last week, but we certainly, and we knew you would rather be with us than what you were doing. So
you are absolutely
thank you so much.
Thank you.
We now turn to Sarah, and Sarah's going to talk about the public comment. And again, I ask everyone indulgence. We're going to try the best we can to make sure this public comment works, but this is going to be our first experiment with it. Go ahead, if you would, Sarah, explain how it works. Well, I'm not sure. Sarah seems to be having a problem with her audio. So let me tell you how it works. We will have public comment at the end of the meeting. It'll be limited to 3 minutes. We will, because some people may be participating by phone and some people may be participating by the Webex, we will give you a 30-second warning and then a 10-second warning, and then ask you when your time has stopped to conclude, please. And there is a way which you will be able to let us know that you have public comment. Sarah, can you put that slide back up if you're able to? And we'll put this back up at the end of the meeting so that people will be able to see the slide. This is the slide. If you have written comment, you can go to our website and put that comment in there, and also let us know for those who want to be heard. We have a mechanism for that too during the end part of the meeting. Okay. Sarah or Kimberly, can you be heard yet? Because we can't hear you before, and we would like to have a explanation of anything further people need to know about public comment, because it's extremely important to task force to hear from folks.
Can you hear me?
Yes, I can.
Okay, I'm so sorry. I apologize to everyone that's joining us on WebEx and YouTube. Yeah, so we will take public comment at the final portion of our meeting. And we will submit written comment that will come through, as well as the process for verbal comment. Similar to last week's meeting, we will have allot 3 minutes, and then I will let you know when there is 30 seconds left, 10 seconds left, and then of course when the time has ended. So my apologies again for the audio issues on our end, but Ken, if you're ready, I think we're ready to move on.
And Sarah, if a member of the public wishes to make oral public comments, they go to this address right here and make that indication. Is that correct?
Right. So if a member of the public who's viewing us via YouTube this afternoon would like to submit verbal comments, in the description section, which is right underneath your YouTube screen, there is a link to join the Webex meeting, so you can join via the Webex application. There's also information available to allow individuals to just call in. We will, for those individuals who would like to submit public comment verbally, we would ask you to use the raise your hand feature, which is available next to your name. So if you were looking at your name on the participant list and highlight your name with your mouse, you'll see a small icon of a raised hand. If you click on that, we'll then take you in the order that your hand is raised. And then for those individuals who are just joining us by phone this afternoon, what we'll do is unmute the lines, and we'll just ask everyone who is there for public comment just to speak up, and we'll take you in the order that we hear you this afternoon.
Thank you. And we do have a hard stop at 2 o'clock today, so can hear public comments up until that time. Thank you again, Sarah, for arranging that. I'll now turn it over to our vice chair, and appreciate him putting this panel together. And when Anthony and I were discussing this panel, the idea was to bring up case studies around the state where the system has not worked like it should. And the idea too is to learn from these, not for the purpose of, throwing rocks at these, although probably some rocks should be thrown. It's to learn from them and to see if there's legislative solutions to these issues where pitfalls have taken place, and maybe the system can be improved through legislative action. Again, I keep pointing that out because sometimes there's court rules which impact some things, and other things there's legislative solutions. And so we're focused on legislative solutions. And so we asked the panel, as they're talking about these case studies, to point out what the problem has been, and if a piece of legislation in statute can be written so to avoid that from happening again. Anthony, I'll turn it over to you. Hopefully we can hear you, and you can introduce your panel members, please.
Thank you. Thank you so much, Clerk Burke. And I do have the honor to moderate the session, case studies from the perspective of the Statewide Investigative Alliance. I'm joined by Lita McHugh, the Inspector General from the Clerk's Accredited Division of Inspector General in Polk County, Senior Guardianship Auditor and Investigator Nancy Abram, also from Polk County, and we have Jenna Murphy, who is an Associate Inspector General too, from the Clerk's Office in Palm Beach County. The Clerk's offices in both Palm Beach and Polk are both accredited by the Florida Commission for Law Enforcement Accreditation for IG offices, and all three panelists are seasoned auditors and very experienced investigators, which is a rare combination. Before we get started, I wanted to share with you how the panel is going to try to present this information to you. First, I'm going to share some basic information and also statistics. I know, surprising to hear me talk about data and statistics. And then Nancy, Jenna, and Lita are going to be talking about the audits that are performed on behalf of our respective home counties, and also the investigations that are performed statewide on behalf of the Department of Elder Affairs. Slightly different processes and reporting mechanisms, but they are more alike than they are different. And then at the end of the presentation, we have some built-in time for the task force members to ask questions and have a discussion. Maybe we can talk about solutions and clarify anything that we said that needs to be further expanded upon. Literally, we can talk about these case studies for hours, so we have a relatively limited amount of time. So I'm going to kindly ask you to try not to ask hypothetical fact questions or questions about a specific case that you're involved with or you have knowledge about. We're going to pretty much refrain from answering those questions. But if it's about process or procedure or how or why we do things, then I would say those are all fair game, and we'll do our best to answer those questions. We're also going to refrain about talking about the OPBG's disciplining process and the administrative outcomes. The Department of Elder Affairs, Secretary Prudhomme and Shante Drones, the OPBG Executive Director, are much better suited to answer those questions and to explain disciplining and regulating the state registered professional guardians. That is truly their expertise, and we only support them in that role. Okay, so If Sarah, if you could advance the slide to slide 3, I'd appreciate it. Awesome. So Clerk Butterfield and Clerk Russian did an outstanding job along with Lee County and Pasco County staff at the in-person meeting explaining the clerk's role, and just to try to help reframe the discussion for Lita and Nancy and Jenna. Pursuant to Florida Statute 744-368, the clerk shall audit the Guardian's reports, the initial reports and the annual reports, and the clerk shall advise the court to its finding. I am not sure if they mentioned it, but it's relevant for the task force to know that statutorily, the clerk receives anywhere from $15 to $225 from the wards of states, for auditing the annual accounting. The clerk is only permitted to receive that fee one time, one per every annual accounting. So if an annual accounting is filed with major issues and a second, third, fourth, or fifth amended accounting needs to be filed, and the third and fourth and fifth accountings are audited by the clerk only receives that audit fee once. And you should also know that the clerk does not receive any fees for the tens of thousands of initial plans or annual plans that are filed, audited, and or reviewed, nor does the clerk receive an audit fee for the final accountings, trust accountings, simplified accountings, or interim accountings. And so it's been my experience that all clerks in the state are substantially complying with the shall statute. On the other hand, we have Florida Statute 744-368, subsection 5, which gives the clerk the permissive duty to perform enhanced audits and investigations to audit beginning balances, attorney's fees, the costs and guardianship fees, the guardian's fees and their costs. Now, paired this with enhanced auditing is the permissive capabilities to subpoena records by affidavit, so we can obtain third-party records, so we can perform third-party independent verifications. I am approximating that half of the clerks in the state of Florida, if not more, are utilizing this permissive May statute to perform some type of enhanced audits. So besides the audit fee for the shall audit, the task force should know that there is no additional funding for enhanced audits. So a lot of people have been asking me, well, why does this clerk do one thing in one county, another thing in another county? And that's really because of the statute is permissive. If it was mandatory, if a shall was used, and if the mandate was funded, I would fully anticipate that 100%, 100% compliance by the clerks for the enhanced auditing portion of the statute. So, okay, so 6 clerk offices who are performing these enhanced audits through an inspector general function formed the statewide investigative alliance in 2014. For Palm Beach County, making enhanced audits, doing enhanced audits made perfect sense because for a lot of reasons. One, we have a very large senior population. And as a result, we have upwards of anywhere between 3,000 and 3,200 cases open and active at any one time. And 2, there's a considerable amount of wealth in Palm Beach County. We are estimating that total dollars controlled in guardianships is well over $1 billion just in Palm Beach County alone. The current alliance counties who formed the statewide investigative alliance are Pinellas County, Sarasota, Lee, Okaloosa, Polk, and Palm Beach County. So collectively, in those 3 counties alone, the alliance has reported or advised their court that there was about $41 million of errors, misstatements, omissions, unsupported transactions, and fraud. We call those issues financial deficiencies. Those audits are centered on professional guardians, non-professional guardians, attorneys, caregivers, and family members, really anyone willing to prey upon incapacitated persons. Collectively, the Alliance has received over 2,350 hotline calls and contacts and referred over 500 cases to law enforcement, adult protective services, or another agency. These statistics are through 2020, so they don't even contain the last 7 months of 2021. These 6 clerk IG offices who form the Alliance are the same ones who now provide the investigative services to the Department of Elder Affairs, Office of Public and Professional Guardians. In 2016, the legislature determined that guardianship checks and balances needed to be improved, and the legislature, spearheaded by then Senator Nancy Dieter from Sarasota, and the legislature charged the OPPG with educating, regulating, and when necessary, disciplining state-registered professional guardians. The department entered into an intergovernmental memorandum of understanding with the Alliance to provide professional investigative services to the OPPG. And we've been independently investigating for the OPPG ever since the MOU, and when the rulemaking process was finally codified in the summer of 2017. Since then, the Alliance has completed over 354 investigations, and we have investigated over 1,550 individual allegations, because you should know that each case usually contains more than one legally sufficient allegation. To date, the Alliance has investigated in 41 counties, and we have identified and reported over $8 million in financial deficiencies to the OPPG. Again, these deficiencies can be errors, omissions, breaches of fiduciary duties that caused harm, and yes, fraud and allegedly criminal conduct. And Alita and Nancy and Jenna are going to be talking a little bit more about those cases. Okay. So I'm the data and statistics guy. And so I have some data and statistics for you to consider. If you go to the next slide, Sarah. If you remember in our first meeting virtually, I told you that our office measures and examines, reviews, logs, and tracks the allegations, investigative findings, disciplinary actions, and really everything in between, and that we understand the investigative process inside and out. So here's a bunch of statistics, and I've sliced these and diced the statistics and up in a variety of ways to help you. I mentioned that the Alliance has investigated 1,550 allegations. After thoroughly investigating using our professional accreditation standards for investigating guardianships, we are able to say that 13.2% of the allegations that are lodged with the state are found and found legally sufficient to investigate by the state are true by a preponderance of the evidence. Well, let me flip that around. The reverse means that over 86% of the allegations are not true. And they are not true for a variety of reasons, and I'll explain more on the next slide. But before I go to the next slide, let me explain the 165 observations. These are deficiency observations. If we are investigating, let's say we're investigating an allegation that the guardian dispersed $1,000 to the guardian's spouse to power wash the ward's house, that's possibly a conflict of interest. And during the course of our investigation, we discover that the guardian is habitually late with filing their annual accountings with the court. The late filings would be a deficiency observation. The Alliance did not start the investigation looking at the late filings, but during the course of the investigation, we stumbled upon the issue and we reported it to the OPPG as an observation. We are not going to put blinders up to problems, nor do we go on fishing expeditions looking for problems. Both go against our accreditation standards and also our ethics and moral standards. There was a public comment last week that suggested that the OPPG should be prohibited from taking action on deficiency observations, and I just kind of shake my head to that notion just a little bit. Okay, let's break down the 86% of the allegations that are not true. Why are they not true? Well, 43% are not true because it's simple. The allegations are false. We independently investigated, we collected a sufficient amount of evidence, and we determined that the allegation was false. Sometimes the allegation is not true because the allegation was not legally sufficient. I'll give you an example. If the allegation is the guardian established a special needs trust against the express wishes of the ward's immediate family, this is not legally sufficient because it does not allege that the guardian violated a statute or a standard of practice. The guardian doesn't need permission from the family or the express wishes of a family member. The guardian needs to account for the assets. They need to go get a court order, but failing to account or to get that court order, which was not alleged, so therefore it's not legally sufficient. Okay, the last category is unsubstantiated, and I personally really dislike unsubstantiated. 12% of the allegations that were investigated were unsubstantiated, but we were unable to make a conclusion based on the evidence that we were able to collect on whether the allegation was true or false. In most of these allegations, there is some evidence that indicates that the allegation may be true and some evidence that indicates the allegation may be false. For some of these unsubstantiated findings, sometimes we know of some possible evidence, but we're not able to get the information that we need to make a more definitive true or false fact statement, because unlike enhanced audits in our home counties, we don't have the ability to issue subpoenas for our statewide investigations. And hopefully Nancy and Jenna and Lita can talk more about this hindrance in their case studies. Okay, turning our attention to the problems, the substantiated findings and the deficiency observations. And I call this the bad stuff. The bad stuff ranges from minor discrepancies, annual reports are turned in late, and when there's really no harm to the ward or there was a technical deficiency or a minor error, to more significant substantiated findings and deficiency observations, such as conflicts of interest, significant financial irregularities, visitation issues or right to association violations, and perjury in official proceedings, to the most egregious substantiated conduct, organized schemes to defraud, collusion, manslaughter, and elder exploitation. Okay, data. Did I mention data? Let me give you some data to consider. I'm going to move through these quickly, and hopefully all the participants will have these slides so you can absorb and digest them at a further time. So since we've been providing our investigative services to OPPG, we've been steadily ramping up our number of completed investigations. The original assumption the legislature used in 2016 was that there would be 31 investigations per year. And as you can see, we're trending up more towards 80 completed investigations this year. Investigations can take us 20, 30, 40 or more hours to complete. And they can take actually much more time. We completed an investigation recently. We had over 500 investigative hours lodged in that one investigation alone. Rather than the number of reports or cases, it's more important to focus in on the number of allegations investigated for each of those cases. We've completed some investigations with 30 and 40 individual allegations in the one single complaint. We just got one recently assigned to our office with over 50 allegations. Okay, but let's take a few minutes just to dig deeper into the problems. And there's a variety of different ways to look at the problems. So for every allegation that we investigate, after we issue the investigation report, we then categorize the allegation into a bigger bucket category. And here are the top 5 most commonly lodged complaints about a guardian's conduct. And here's how you read this list. So on the top, for breach of fiduciary duty, the Alliance has investigated 153 allegations that the Guardian's conduct breached a fiduciary duty to the ward. Now, if you look at the parentheses at the end of the line, you will see 32 out of the 153 allegations were true or substantiated, which is 21% of the allegations. So the rest of the top 5 most commonly lodged complaints about a guardian's conduct are guardian's decisions were not in the best interest of the ward. The guardian's conduct breached their duty of care for the ward. Unprofessional conduct, isolation, or visitation, which are serious accusations. Another way to analyze the investigative data is to look at the total number of substantiated or true allegations. And this is pretty much the same list for the most lodged complaints, but guardians exceeding the authority that the court gave them makes it onto this list. And also misuse of assets makes an appearance on this list, along with breach care and isolation, right to association. Those 2 things fall off. So yet another way to analyze the allegations is the most frequently substantiated allegation. Guardians exceeding the court's authority makes an ugly appearance again. I think this is statistically relevant because we've investigated a form of this allegation 39 times. Okay, I am almost done and on to Lita and Nancy and Jenna. I pulled together a couple more interesting statistics, substantiated allegations about do not resuscitate orders. Okay, the Alliance has investigated 10 times. 2 out of those 10 times we have substantiated allegations, and I think you can all guess which is one of those investigations. Attorney's fees, communication. I would put those in the we can do better category. How about conflict of interest? Some problematic cases that Jenna is going to be talking more about. And finally, guardians are struggling. Sarah, if you go to the next slide. Yeah, there you go. Thank you. Guardians are struggling to comply with the quarterly personal visit requirement, and the governor's COVID emergency order does not account for the non-compliance. Seems like to me, it seems like a very basic guardian services, but far too many times guardians are non-compliant. All right, more interesting stuff. I get to stop talking, and we get to hear from the boots on the ground, the clerks on the front line. And up first, we have Nancy Abraham from Polk County. Nancy?
And just so y'all know, we're going to entertain questions at the end of the presentation, if that's fine. So go ahead and write down your questions, and then the panelists will answer them.
Thank you, Clerk Brooke. Nancy?
Thank you. Good afternoon, everyone. First, I wanted to share with you the different types of engagements that we perform in our circuit as a study circuit. Not all offices categorize their enhanced audits in the same manner, but in our circuit, under our clerk's duty to audit the guardianship, first, the probate staff would complete a level 1 audit, which would be described as a desk review. The desk reviews are limited to confirmation of certain items on the accountings. If the probate department notices any issues or problems, they would forward the guardianship report to the Department of Inspector General for our review. We would then perform a level 2 audit, which is an enhanced confirmation of items, additional analysis, or requesting more supporting documentation. A level 3 audit in our office involves visiting the ward or conducting interviews as necessary, as well as looking at even more transactions. So the guardianship I would like to share with you today involved a ward that was paraplegic from birth. Her natural mother was appointed to be the guardian of the person and the property. To avoid continuously saying the ward, I'm going to refer to the ward as Jennifer. Jennifer had been in a guardianship for several years. Jennifer received a settlement that provided continuous income starting at $7,000 per month for her care, which was deposited into a restricted depository. This income would increase over time. Currently, her monthly income is $10,000. Initially, desk reviews were performed by our circuit's probate staff. However, they noticed some problems and notified our office. So our office got involved about 7 years ago, and we conducted a level 2 enhanced audit. At this time, Jennifer was a teenager. We discovered through our audit that Jennifer's mother was withdrawing funds above and beyond the court-ordered disbursements by $6,000 for the 1-year period. We noted that there were multiple orders over the years authorizing Jennifer's mother to withdraw funds, reoccurring each month for various reasons. We reported our findings to the court. The court, at their request, we conducted a level 3 enhanced audit. We discovered disbursements that were unauthorized by the court, such as lavish vacations for the entire family, excessive entertainment, large amounts of house repairs and modifications, medical equipment, including lifts and therapy equipment, and a purchase of a therapy pony. We noted on the accounting that there were several unexplained fees that were charged to the bank accounts. There were late fees for the mortgage payments. There were unauthorized loans by the guardian, savings in a money market account earning 0.03% interest, and the amount was relatively small in comparison to the income that was being received each month, since the monthly income was expended at the end of each month. We reviewed the orders in detail and found that some of the orders allowed funds that were no longer being used by Jennifer. So included some kind of activities that she was no longer involved in. She was discharged from certain physical therapy, but those orders were still active. She was graduating, and so the supplies and needs for school were no longer needed. We proceeded to dig a little deeper into the past accountings and found the same repeated non-compliance with the court orders, excessive purchases, and unnecessary fees. Over the guardianship period, the guardian exceeded the court-ordered disbursements in the amount of $100,000. Now, our audit included visiting Jennifer at her home, which we had several reasons for. We wanted to see how Jennifer was cared for. We also wanted to know whether these repairs to the house and modifications were necessary. And was there really a therapy pony, and how is it being used? We visited Jennifer in her home, and we were able to see that Jennifer was well taken care of. We were able to see that the house started as a custom floor plan, but the floor plan was expanded to make it handicap accessible. We were able to see that these modifications were to the house firsthand. We felt that they were necessary and reasonable. We were able to observe the medical equipment and the lifts. And we also confirmed that, in fact, there was a therapy pony. However, it was only used for her enjoyment at the time, since Jennifer's physical condition, she could not ride the pony. The visit to Jennifer's house gave us a better understanding of her environment and her needs. There were no concerns about Jennifer's care. However, Jennifer's mother was not able to manage Jennifer's money in the guardianship. At a court hearing, Jennifer's mother admitted that she did not review the bank statements for the restricted depository and was not aware of the fees charged. Jennifer's mother was not maintaining receipts or invoices for additional disbursements that she was making with the guardianship funds. As a result of the level 3 audit, we recommended going forward that Jennifer's mother would retain receipts, that she would repay the unauthorized loans that were taken from the guardianship funds, that Jennifer's mother would consider investing some of the guardianship funds for a greater return. We also recommended that Jennifer's mother would provide a monthly budget to the court with documents to support the budget. The monthly budget that was provided by the guardian included large amounts designated to family vacations and entertainment. So we proposed a revised monthly budget for these categories, but it was still based on the guardian's original budget that was provided. We also proposed one single order for one monthly disbursement of $9,000 to include the expenses needed for the care of the ward. The purpose for the budget was so that Jennifer would be able to build a savings account sufficient for her future medical needs or long-term care that would not be covered by insurance, or perhaps if something happened to Jennifer's mother, that she would not be able to care for her, so that Jennifer would be able to pay and receive services for her care. The court ordered the budget and the one monthly disbursement, voiding all past orders for monthly disbursements to the guardian. We continued to perform level 2 audits on the annual accountings for the next few years. Unfortunately, Jennifer's mother continued to exceed the court-ordered monthly disbursement amount despite multiple notifications. Over a 2-year span, the court-ordered amounts were exceeded by almost $65,000. She continued to take loans from the guardianship funds and did not maintain supporting documentation for the disbursements. We concluded that it would be in Jennifer's best interest to have a professional guardian manage her money. We recommended to the court that a professional guardian should handle Jennifer's finances, and we included in our recommendation that a portion of the budgeted monthly disbursement would be given to Jennifer's mother for the day-to-day expenses, but then the professional guardian would handle the fixed monthly bills and the remaining funds in the guardianship assets. Now, this arrangement seems to be working very well, and Jennifer's savings account has been steadily increasing, so we're able to see a substantial amount to support her future needs. Thank you.
Great, thank you so much, Nancy. Next up, we have Jenna Murphy. Jenna?
Hi, good afternoon, everybody. I'm going to be talking, I'm spending most of my time this afternoon discussing three of the more significant cases and allegations and observations that I've investigated, all of which involved conflicts of interest. So a conflict of interest arises when an individual has some sort of personal interest that can be perceived as self-serving or adverse to the best interest of a ward. So to be clear, if a potential conflict of interest was disclosed to the court and it was approved by the court, then there's no conflict. The issue arises when that potential conflict of interest is not disclosed to the court. So here are just some examples of that lack of disclosure of these potential conflicts of interest that we noted. As Anthony mentioned earlier, we report on both allegation findings and deficiency observation findings. And this case is a perfect example of both of those. This was a guardianship in South Florida, and we conducted an investigation in which the original allegation was based on an alleged conflict of interest. And upon reviewing the court record, we noted several significant additional potential conflicts of interest. I'd like to elaborate when I say that when we review the court record, when we investigate a case, we're reviewing the entire guardianship court file. We're reviewing any related court files and other documents that we gather from other sources as part of our investigation. We're reading every word, every line of every page of every document. And additionally, we like to develop a full profile of the guardian and their staff in order to get a full and complete understanding of all the parties that are involved in the guardianship, what their roles are, etc. So in this particular case, there were a string of potential conflicts of interest that began to emerge. First off, there was a house cleaner that was providing services to this particular ward, and we learned that this was also the guardian's house cleaner. And the guardian also hired the house cleaner's sibling to provide massage therapy services to this ward. And I'd like to mention that it was also discovered that this massage therapist did not have the appropriate licensure to provide massages, which could be a detriment to the ward's health. There are certain laws and regulations that are in place for massage therapists, and this individual was not a licensed massage therapist in the state of Florida. Additionally, the guardian hired one of her employees' spouses to provide sort of handyman style work to the ward's property. This might include fixing little things inside of the ward's home or installing items in the ward's home. The guardian also hired one of her employees' son's friends to provide transportation and other services for this ward. So there were several conflicts of interest that we noted in this particular case, but of considerable note was we found that the guardian was part of a multi-level marketing organization. I'll refer to it as an MLM. So a multi-level marketing organization basically means that somebody has to, in order to be a member or a part of that organization, they have to make a certain amount of purchases or spend a certain amount of money or buy a certain amount of products to maintain their status within that MLM organization. And this guardian, we learned, was purchasing products for their wards, which allowed for the guardian to make commission off of those purchases. Upon reviewing the court file, I would notice receipts for purchases made to this MLM organization. And the issue was that the court file did not reflect that the guardian was making commission off of these purchases. It only reflected that the guardian was seeking reimbursement for the purchases. Additionally, several food places, like I can think of one off the top of my head, Chipotle, for example. When you go and you scan your app, you might accumulate some points, and after a while you get a free entree or something like that. So this MLM organization allowed for its members to accumulate rewards similar to what I just described and make purchase. So when she would make a purchase on behalf of her wards, she would accumulate points, and the guardian did not utilize any of those rewards points when making purchases for their wards. Now, if we had the ability to subpoena records, this would have been of a tremendous help and benefit. We could have subpoenaed the entity to obtain source documentation, which would have helped to streamline the process and allow us to get those documents necessary to make the finding, instead of having to rely on non-source documents. So another allegation that we've investigated was pertaining to a professional guardian that was allegedly selling ward's personal property without court approval. And upon reviewing the case, not only was the ward's personal property sold without court approval, we learned that the guardian's staff sold the ward's personal property at what you would call like an estate sale or a garage sale type of environment. So as I noted this, I observed the fee petitions that were filed by the guardian, and I started to notice that the cost of the time spent by the guardian staff to prepare for and set up and then ultimately facilitate this estate sale was greater than the amount of the profit that was generated from the sale of the personal property. This led to the ward suffering basically a net loss from the sale of the property. Instead of hiring an estate sale business to facilitate the sale, the guardian staff conducted the sale and profited from it, essentially. This discovery led to other realizations, such as lack of documentation for the items that were sold and how much the items sold for, and most of these items were sold in cash. Now, it's important to note that this was a coastal populated area in Florida, not an unpopulated, more rural environment. There were people that the guardian could have hired to assist in the estate sale process. The guardian informed us that they did not seek estimates to hire an estate sale company to perform the work, and ultimately indicated that COVID prevented most estate sales and from providing those services, but there was no evidence provided by the guardian of that. Additionally, the guardian also petitioned the court for approval to store property of the wards at an undisclosed location, naming it just an off-site storage place. But the guardian did not disclose that they were actually the owner of that location. This raises a variety of issues, such as if you were to store property at a facility that had AC or had surveillance cameras, had insurance to cover if there was some kind of loss of the property due to a hurricane or something. There was none of that in this instance. Of also significant note, as I was reviewing this guardian's petitions for fees, I noticed that there was a reimbursement request for the hiring of laborers. Now, my antennas kind of went up because most of the time when guardians seek reimbursement for something, if they made a purchase, they have a receipt, or if they indicate that they hired such and such a company. The word laborers kind of stood out to me, and the entity or people that were hired as these laborers was not disclosed. And upon questioning, it was discovered that the guardian hired her own children for the service. So lastly, this last case, I would need hours to fully discuss, but I will give some of the highlights. Basically, in northern central Florida, a guardian who is also an attorney was appointed amid significant conflict among the ward's family members. And upon investigation, we noted that the guardian awarded themselves hundreds of thousands of dollars without court approval and without transparency to interested parties. Part of this included performing work as an attorney on behalf of the ward, and this representation was not approved by the court for this appellate work. The lack of filing fee petitions resulted in the court not being able to fully exercise their oversight duties. So again, I only have limited time to discuss some of the more significant findings that we've noted, and thank you very much for.
Thank you, Jenna. Outstanding job. Very, very complicated, complex investigations, and you were very succinct, so I appreciate that. Okay, up next we have the Inspector General from Polk County, Lita McHugh. Lita?
I just want to make sure you can hear me.
Speak up, Lita, we can't hear you.
Oh, sorry, let's try this. I had to switch to my headphones because the feed was getting really slow on using the computer for sound. So I hope you can hear me now. So I'm going to focus on a couple of major categories of issues that we found, and I'm not going to go quite as deep into all of the aspects of these case studies because I think these two issues are of interest to the task force and probably the people the public who are joining us. So these case studies are going to come from two sources. We have the clerk's duty to audit within our own circuit. And so some of these cases are going to be within our own circuit where we've got a subpoena power and a relationship, or how do I say it, a reporting stream to the court. I'm also going to include a few cases that are from our SIA investigations, which were assigned to us by OPPG at the Department of Elder Affairs. So in our own circuit, as you probably heard from listening to Nancy's case study, our audits are based on red flags that we find during the audit. And Clerk Butterfield mentioned this last week, that it is a risk-based audit. So some of the more common things that we find in our audits within our own circuit, in fact, the most important thing is questionable disbursements. Those would be purchases that we can't show for sure are for the benefit of the ward, or disbursements of cash to the ward because it's not traceable, lack of maintaining receipts, valuation of the ward's assets if they own a home or an automobile or equipment, personal property. Sometimes we request further information over those types of issues. We also look really closely at the attorney fees and the guardian fees because those are frequently some of the largest disbursements in the annual accountings. Closely behind that, if a ward is staying in a facility of some type, as mentioned last week, if they're staying in a facility, you expect to see 12 monthly payments in a consistent amount. So if you see varying amounts of payments, it may be that the guardian has fallen behind and then has to catch up. The point is, we use some checklists that have been established by the FCCC, the Clerks Association, and they're very detailed. Depending on how you format them, they are 6 pages or more. And we work our way through that to make sure we've covered every base on every single audit that we do. And in our circuit, the probate staff also, even on their desk reviews, they use the same checklist, although they may not request as much documentation as we would do. So my first case study, I'm going to talk about the issue of restoration of rights. These are some of the more difficult cases that we have seen, and I know it's of great interest to the community. So as Nancy did, I'm going to call this ward Susan because she seems like a Susan to me, but that's not her real name, just as in Nancy's audit, Jennifer was not that person's real name. So this case study, I'm not going to put everything in, but I'm going to talk about the stuff that kind of relate to the issue of restoration of rights. So this complaint came to us. It had somewhat of a laundry list of complaints. Some of the complaints were that the ward, or Susan, was not getting proper medical care. But the main complaint was that Susan wanted her rights restored. And actually, this complaint came from Susan. So let me tell you a little bit about her. She was determined to be incapacitated about 8 years ago. At that time, she was in her perhaps late 60s, early 70s. Very bright. In her day, she and her husband were definitely social influencers. They had a lot of money and they were very active in their community. But as time went by, her husband was a bit older than her. He was a little more frail. And when we became involved in the case, he had recently passed away, and she'd also just lost her dog, and that was important to her. Kind of looking at her history, we found that the reason she was declared incapacitated was she had some mild cognitive impairment, kind of due to based on years of alcohol abuse and Xanax abuse. She had had multiple attempts at suicide, and that was reported by her daughter, and had been physically and verbally abusive to her daughter and other family members since the daughter was 17, which was a few years before that. She had repeated visits to the emergency room for accidents and intoxication. Law enforcement was called to her home 3 times in a 4-month period. She was assaulting family members. And then what really initiated the guardianship case was that she had a housekeeper that was exploiting her financially in order to provide her with alcohol. She had an inability to care for her husband at the time. He was quite frail and elderly. She was unable to manage her finances. She had a lot of money to maintain, and she just was burning through it in record time. She wasn't able to manage her medications or make good sound medical judgments. So she was deemed incapacitated, and a professional guardian was appointed. I will say there was no family discord that we became aware of, but she did have 2 daughters, but they preferred to have the professional guardian care for her finances and her person. So the guardian got her established in a really nice residence at a Brookdale. If you know different assisted living facilities, Brookdales are generally very well kept, very nice, have a lot of activities. However, Susan would get hold of alcohol, get drunk, cause a ruckus, and also she was smoking within the facility, which was not allowed. And so she was asked to leave. So the guardian looked around and found another facility that had a balcony. She was on the 2nd floor. She had an open balcony so she could sit out there and smoke without annoying anyone. And she was also able to have a pet there. So I went to visit the ward. She was quite charming. Very, you could see her apartment was well kept. Her person was well kept. She was able to communicate. And that is Susan on a day when she's not drinking or abusing prescription drugs. I talked to her about her concerns, and she said, well, first of all, don't tell my guardian that I talked to you. And I said, we'll do what we can. Just tell me what your concerns are. So she had some medical concerns. She said she thought she needed to see the dentist more often and the ophthalmologist more often. But her main thing was she wanted to get her rights restored. So I talked to the guardian and interviewed some family members, and I found out that the guardian would set these doctor appointments, and Susan would either not show up or would cancel them for no particular reason. She also was still using the small amount of spending money that the guardian gave her and either sending someone to buy alcohol or bartering for alcohol. So again, she would get, she would cause herself some more problems. And one of the more bizarre complaints that she made to me that I didn't quite understand was that she complained that the guardian said that they were going to ship her off to Miami and no one would ever hear from her again. Excuse me just a moment. Okay, so I asked the guardian about that. And what the guardian said was that she was trying to get Susan in to see a neurologist in Miami, and she had had success with that client getting neuromapping done. So this neurologist did neuromapping and recommended a change in that client's medication, and the result was she was able to get that person's rights restored based on this medical procedure. So she was trying to talk Susan into this, and Susan was somewhat afraid of it, didn't want to do that, and not really any good reason. I think she seemed to think that the guardian was trying to hide her away somewhere. So at the end of the investigation, after looking into all those, what I did do is I talked to Susan again and said, look, your guardian is obliged to help you try and get your rights restored if that's possible. So may I please talk with her about that? So I notified Susan, and Susan said, sure, that's fine. And I talked to the professional guardian, and she said, I'd be glad to help her. Let's see, see what we can do. And I did check back in on the case, and I did see that there was a suggestion of capacity filed. They're still working on that. I did find out that Susan had a friend downstairs who had who had passed away and had a motorized scooter that the family then gifted to her. So most recently, Susan was jumping on the scooter and driving down to the liquor store and buying more alcohol, and once again kind of causing a bit of a ruckus at the facility. So there's not really any resolution to this, but this kind of opens up what are some of the options that the guardian has. I think something that the task force could look at is if someone is capable of having their rights restored, don't just throw them out in the world. Is there some type of support group that could be established, or means of, either for drugs, there are, I don't know what you'd call them, but substitutes to help people not go back onto their prescription abuse, or, alcohol support groups or whatever. But the point is there should be a difference between a guardianship from someone who's having a substance abuse problem and a guardianship that is an older person with a terminal condition, and they should not all be in the same basket of court case types. So I'm going to move on from that, and I want to talk about one of the issues that we have seen the most often, and that is isolation from family members. And I can draw upon a number of cases either within our own facility, our own circuit, or from complaints that have been assigned to us by OPPG. We've had 2 or 3 cases where either the guardian or the facility says that particular family members come in and upset the person that's in the guardianship. This is pretty common. When we start looking into allegations of isolation of the family, there's a number of scenarios that we see. So this is one, that a particular person is upsetting the ward. I had a case with OPPG where the nephew and his girlfriend were providing crack cocaine and marijuana to the ward, and also having drug parties within the ward's home. And so getting her out of that environment and getting those particular family members out of the house really helped a lot. But obviously the people that were cut off from access to the ward's money were not happy about that. I had 2 cases, and actually a third case, my very first case, complaining about a daughter being kept away from her mother, and the facility staff reported that this daughter, every time she visited, would bring in a big gulp, a large drink, and insist that her mother drink the whole thing down. And then after that she left, the facility staff would notice that the ward seemed groggy, out of it, lethargic, just not right. And their suspicion was that the daughter had been caring for her mother prior to the guardianship, and so likely had some of her previous medications, or maybe even was putting some over-the-counter medications in that. So they obviously did not prevent the daughter from continuing to see her mother, but they forced her to be out in public. She was not allowed to go into her mother's room alone with her, and they had to have a staff member just kind of keep an eye on things. I had 2 cases we got from OPPG, and that was a situation where family members would ask to take the person subject to the guardianship out of the facility for like a family dinner on a Sunday, or go out for an evening dinner, and then never return the person to the facility. One of those cases, the ward actually ended up in another county, like 3 counties away, and they had to get a sheriff's deputy from that county to go pick up the ward and bring him back to the facility because he was missing his medications. He actually was going to miss a doctor appointment. I've had there was one case that we had. It was a young adult. I'd say she was in her 40s, maybe 50, and had been in an accident and had some pretty serious brain damage done. And one of her sisters took her out of the facility for lunch and again did not bring her back. And in the time, she got her sister to quit claim her condo over to her. So she stole the ward's condo that had been bequeathed to her by her mother, and also stole a bunch of money out of her bank accounts. So this person complained to OPPG that she was being isolated. We were able to confirm this story with 2 of her sisters. I had a local case within our circuit of a boyfriend of a similar developmentally disabled adult female. However, he was probably 20 years her senior. During his interview with us, he told us that he was helping her get her finances in order. In talking with the ward, we found out that she thought he had helped her buy a Mercedes, a Volvo, and a motorcycle, but they were nowhere to be found. The Guardian had looked for any title on the state's database to see if she had any vehicles, and she could not find any evidence of that. However, eventually going back to this complainant, who is the boyfriend, he admitted that he had the Mercedes, the Volvo, and the motorcycle, and he was keeping them in safekeeping for her, but she didn't have access to them. And she did not have, sorry, go ahead.
We've gone way past our time here, so we do need to wrap up.
I'm about to wrap. I'm close to wrapping here. So these are just some samples of the cases where the ward was being isolated. What we found is that the Guardian does their best to work out a way for the ward to visit with that family member in spite of any exploitation. The key is whether does the ward want the visits or not. And that said, I'm done.
Okay, thank you. And I'm surprised y'all didn't bring up anything with real estate sales, because that seems to be a big issue. Maybe it's just in Pinellas where something gets sold from the guardianship, and then it's shortly after sold again at a very high price. So did y'all not see these as far as this happening?
I've had a couple of cases like that, Clerk Burke. It didn't involve a professional guardian, but had to do with non-professional guardians, attorneys, and family persons. So
Okay.
yeah, I mean, our work on behalf of the OPPG is complaint-based. If those complaints need to be lodged with the state first, and then forward to us. But
I'm going to call on Hillary, but also I have two questions concerning the reports that the clerk's office does for the judiciary. Are those open for public inspection?
I think that's determines what jurisdiction it is. In Palm Beach County, we have an administrative order where we issue the reports to the court. It's docketed into the court's record, but it's up to the court on who has access to that report. 99.9% of the time, the court allows access to those reports. There are the small fraction of cases, sometimes when they're involving criminal investigations, that the court will deny those petitions, but the vast majority, it's opened to the parties.
Reports, are those open to the public?
Those reports are public record. Anyone can submit a public records request.
Okay,
to
open to the public. That's the answer. We don't have much time. We want to call the other members. Hillary?
Thank you for acknowledging me. And I move that we discuss at one of our future task force meetings, to which the topics are to be determined at length, OPPG. and their practice and patterns. So that is the motion that I'm making right now.
Okay, I'm unclear what you're asking for, Hillary.
I'm asking for us at one of our future task force meetings to discuss with Mr. Prudhomme of Elder Affairs and Shantae Jones that the task force discusses OPPG and what they're doing with the complaints.
Okay. Mr. Perdona, are you still on the phone with us or on the call here? I'm trying to look at my.
Yes, sir, I am.
Oh, there you are. Would you be willing to be a program in the future for us at one of our future task force meetings?
Of course, I think, the purpose of these meetings is to explore every such issue regarding guardianship. So of course, I'll be happy to participate with Shantae Jones on such a discussion.
And I think it'd be helpful if the task force members would send to our staff person the questions you have as far as what you would like Mr. Perdona to cover, and that would be helpful in him preparing his report.
Fantastic. And I know we're really limited in time, and I must say a few things. This whole, everything that we listened to today was anti-family, and nothing was really mentioned about the guardians. It is absolutely deplorable. So many complaints have been sent into OPPG and nothing has been done. As per Mr. Palmieri with the records, I requested, made an open records request concerning Teresa Barton. My response from OPPG was that I would have to pay $522 to get the reports on the times that she was reprimanded, because we know that no one actually is held accountable. And I'll just very quickly read one thing. You know, everyone's saying, oh, guardians are great. You know, isolation doesn't happen. Everything is really, really good here in Florida. Very short, Ken, and thank you. My name is Denise Wilson. I'm a clinical manager with Maxim Healthcare. On several occasions concerning guardian Susan B. Whitney and the ward Omar Rojas. Susan was appointed guardian over Omar in 2019. Since that time, Susan has presented herself in a very unethical, aggressive, and inappropriate manner with not only myself, but with other employees. Susan alleged the mother was doing wrong. This is not correct at all. The mother takes perfect care of Omar. So I'm just going to jump to the part that everyone needs to hear. This nurse, who has no conflict or no horse in the fight, said that guardian Susan Whitney said, and she quoted her verbatim, that in order to get Omar out of the house, she didn't care if she had to put a noose around the mother's neck. We made a complaint with OPPG, nothing was done. Tracy Samuel Hudson, we've made numerous complaints about when she was running her crime spree in Pinellas and Pasco. We told them, and you know what the Inspector General's office said, Hector Collazo and Andy Natale? Well, seems like we have a vigilante mob going after this nice guardian, and when there's more than one complaint made, it just seems that it isn't, credible. We warned OPPG for years about Tracy Samuel Hudson and what she was doing. We warned you, Anthony, about Winrod Douglas. But you know what? Nothing was done. So I can only contain myself, and I'm a very respectful person. I do my research, and this whole almost 2 hours is just sugarcoating. Someone gives someone a big gulp. Well, did you analyze the soda to see if something was, in that soda to make the mother kind of loopy? This is just, it just seems like whitewashing. And honestly, OPPG really, and the Florida Bar, is perpetuating what is being done in the guardianship system in Florida. And I do thank you, my friend Ken, for letting me speak as long as I did.
Thank you, Hillary. Shannon, you're now recognized.
Thank you, Clerk Burke. I'm listening to this, and I understand that it seems like the referrals are coming from OPPG to the clerk's entity. And it sounds so much like a really good court monitor investigation. Because what I'm hearing from these investigators is really very focused on the ward and protecting the ward, which is really what the court monitor is intended to be for, right? OPPG is to investigate bad actions by professional guardians. But what we really, it sounds like to me, what they're doing is a very thorough investigation that might be better suited under a court monitor situation, where what we're all trying to achieve is protection of the ward, as opposed to investigation of a professional guardian. And so I'm wondering, as we're trying to figure out a better way to improve guardianship, if we might continue to focus on improving the process for court monitoring. And I say that because we know that clerks are judiciary, and they are intended to be an extension of the judges. And there's this thing called the separation of powers that requires executive branch, which might be police officers or investigators, to be separate and apart from the judiciary, right? So having judges become investigators, like if we can imagine what would happen in a criminal case, if we had judges investigating crimes and then sitting in judgment of those crimes, it's a problem, right? We want to make sure we have separation of powers. And so I am so impressed with the level of investigation that happened. I would feel a lot better if these investigators were in fact court monitors that were separated from the judicial branch of government. And so I hope that during this process, we can start to look at creating that kind of funding for a court monitor program, like we've seen with Winner, Solomon, Cuthbert, where it's like a separate entity, and that idea of a court monitor may do what we're looking for here, which is really to be focused on the ward and protection of the ward, and that may create a process like we've seen. That's all I had to say.
Thank you. I want to welcome Judge Morley, who's with us today. She's a special advisor to our task force, and we haven't had a chance to really get the chance to hear from you. And I would just want to give the floor to you for any comments you have concerning your interest in this topic, Judge.
Well, I have a passionate interest in the topic, and apologize that I wasn't able to join the meeting from the start, but my job gets in the way of a lot of things, including meetings as important as this one. But I am glad to see the variety of people on the task force and disciplines, and so I look forward to hearing the conversation.
Thank you. And Representative Burton, are you still with us? I know you're recovering from surgery.
Here.
Representative Burton, I'm going to put you on the spot. I know, part of the function of our task force is to produce a report with legislative recommendations. You're a well-respected legislator, and you have devoted yourself to the interest of the elderly. I certainly would appreciate your comments as far as we approach our work.
Well, I certainly think that I want to thank those who presented today, because quite frankly, in my work in the legislature to date, most of the conversations I've been engaged in have not been from what I'm going to call front line of an investigation. And I thought really, Mr. Palmieri, your data early on related to the number of complaints and the number of investigation, the outcomes of those complaints is very compelling. Unfortunately, I've noticed there's quite a bit of chat going on during our meeting this afternoon, because this is a very, as you all know, a very, very emotional topic for many, many parties who are involved. And so the challenge that I think we have is moving beyond the personality, if you will, of the issues and some of the particular cases, because and looking at the overall picture. And that's why that data is so important, I think, and trying to come up with something that, while I don't think we will ever be able to satisfy everybody, we need to have a system that protects individuals who are under any sort of, I want to say, incapacitated state where their rights and their properties and anything related to them is decided by somebody else. It's a very, very difficult thing to do, but I think it's very, very important. And I appreciate the fact that we have such a diverse group, not just on our task force, but in the presentations. So I'm happy I was able to at least listen in this afternoon.
Thank you. And thank you, Representative Burton, and speedy recovery. I'm also pleased that Bob Astolis, from the Deputy Executive Director of the Florida Department of Veterans Affairs, is with us today. We are not able to have you at our in-person meeting, but we're glad you're here, Bob. Thank you. Do you have any comments you would like to make?
Well, thank you very much. And I'm sorry I missed the meeting. I did have a conflict. I too have been really moved by the conversation today and hearing the stories from the frontline workers, and I appreciate all their input.
Thank you, Bob. And we have another new member of our task force, and that's Michael. Michael, it's good to have you here with us today. And do you have a comment to make?
Yes, thank you, Clerk Burke. As soon as I got your letter from in the mail, I was like, oh my God, I got a letter from the Clerk of Court of Pulinares County. I did not do it. But my name is Michael. I'm the co-chair of SDM for Florida, where I'm in the process of writing a bill for supported decision making here in the state of Florida. And I'm a proud county resident of St. Lucie County. And the topics that was made today really simulated my story 100%, because I was basically, back in 2014, I was incapacitated by the court here in St. Lucie County, had all my rights taken away. And, I, as of, the guardianship, I've noticed one thing, that we are labeled. We are labeled as wards. We are labeled as, but we shouldn't be labeled as individuals with people with special needs. We're all human beings. Like, I wear a shirt around the town that says label jars, not people, because we should not be able to be labeled as individuals. We are all human beings. Actually, when I got my rights back, I've accomplished a lot of things. Like, I'm actually a security guard for the state of Florida. I work at a rich yacht club, which I wish I had a yacht, but that ain't happening anytime soon. But there's so many accomplishments that we could make. And what I'm hoping to do with this bill is to make a difference in people's lives and make a difference in individuals and change the guardianship processes that we have. Because I don't think it's fair that anybody can file a guardianship against somebody. Like, to me, that doesn't add up. And when you call Adult Protective Services, when you are, being mistreated, all they do is look for stuff, and then if they don't buy it, they close out the case. But they don't know what's really behind the doors after they leave. You get what I'm saying? So that's my comments, and I look forward to working with you guys, and I look forward to making a difference in the guardianship statutes.
Fantastic.
Thank
Nice
you,
to
Michael.
meet you, Michael.
Thanks for being part of our task force. We certainly
Thank
appreciate
you.
it. Thank you for your comments. And just so you know, your particular clerk, Michelle Miller in St. Lucy's participating in, she's listening into this. So you have a good person there. You should go meet her. Tom Hall, who is our staff person. Tom, you have some comments? Tom is out at the West Coast. He's on a vacation. He may be having a tough time with his communication. Tom,
Mr. Chair, this is Tom. Can you hear me now?
Yes, I can.
Can you hear me now?
Yes,
okay.
You're right.
I just wanted to make thank you. I just wanted to make a point of order. There was a motion made. The guidelines require that motions to add something to an agenda be in writing and be made 10 days prior to the date you want them to be on the agenda. And of course, a motion needs a second. So just nothing against the motion itself, just raising the point of order.
And I appreciate that, Tom. And it was a suggestion really for a future program. And it looks like we're going to be able to accommodate that without the need for a motion. So
thank you.
We're going to go forward with that. It's really now time for public comment because I want to respect that time. Sarah, I know you're keeping a list of public comment. I'm not sure if you're going to email me that or not, but I'm going to go ahead and just because I have his name first to me, and maybe you could send me the list after that. Douglas Franks. Mr. Franks, you've asked for public comment. You're now recognized. You have up till 3 minutes. Are we unmuting everyone?
Hello, can you hear me?
Yes, we can. Mr. Franks, please go forward.
Thank you, Anthony. Again, I know several members. Richard, we have a close relationship at the Capitol one time when we had to speak out, and he gave us the opportunity to have a meeting with them in the old Capitol, the Supreme Court portion of it, which is kind of ironic. I'm plastering the internet with my mom, Ernestine Franks, freeernestine.com. Y'all have all heard of that website. My mother is a perfect example of how things were done right, where there was some due process, but a judge is quite able to just say, you know what, forget it, because your family's not getting along, and I'm going to override Mrs. Franks's expressed advanced directives, her testimony in court, and she even went to a neurologist and had an examination in the middle of the court hearing on Wednesday, and that was given to the judge, where the neurologist, board-certified neurologist, said this woman doesn't have has the right, of a capacity, and she can make these decisions. And his feelings that this was Mrs. Ernestine's Franks's case, and she also knew the ramifications. All that was given to a judge, and a judge can still say no. So here's the deal: we can't. All of us advocates, we don't trust the courts. We don't trust them at all. We don't trust the lawyers. Even we asked for capacity, and Belinda DeCozen, I need to say her name, she said, well, Ms. Franks could have a test for capacity, but it can't be to have her capacity fulfilled or given back to her. I mean, that's insane. That is insane that someone could even make that comment. And who looks after the lawyers? The board of lawyers that look at other lawyers and reprimand them, and hell, that will never happen. So again, this court monitor, someone independent, we need that. I also videotaped all the meetings I had with my mom that she had to pay $100 an hour to be with me. $100 an hour. And I want y'all to watch these things, and you will be amazed at how my mom at 94 had her wits about her, and how at the end we got Amanda Haystack with Disability Rights Florida to say, hey, I want to be your mother's attorney. Well, the other side got frightened and they denied it.
30
seconds. The court denied it. But that was enough to scare them, along with all the other stuff. So we went to mediation, and it wasn't a mediation, it was a hostage negotiation where we paid money to get my mother back. My mother died in my arms after 45 days. And I'm in this fight until things change. But I want y'all to look at Miss Ernestine Franks, my mom. She was an incredible woman. And you want to talk about women's rights? All these women, that's what it is. Mostly women are being tortured by these unscrupulous guardians. So that's what I got to say. And thank you very much.
And God bless you on your mother. She's in heaven now, we hope. Twala Sketchley, you're now recognized. Twala Sketchley. Maybe that person had to leave the call. Sarah, I'm having a hard time figuring who's next. Oh, Dr. Sugar, he's next. Dr. Sugar, welcome. You're now recognized.
Thank you. Thank you very much.
Boy, Dr. Sugar, you're tremendously echoing. Why don't you try again, please?
Sometimes that happens when you've got two devices in the same room.
Yeah. Is that all right? Let's try that again.
Sounds better, Sam.
Thank you. Thank you for this opportunity. I have taken the opportunity earlier today to send you written remarks, which will, I think, speak for themselves. But I wanted to comment very briefly on what I've heard this afternoon. Some of you know me, some of you don't, but I've been involved in this so-called fight for a decade. And I think with this particular problem. What I've heard today, though, is that everybody who's spoken has found the flaws in this system. Whether you're a clerk complaining about families, whether you're a family member complaining about clerks, whether everybody's complaining about lawyers, or whether you have the temerity to complain about the judges. This is a broken system from start to finish. And in my opinion, after a decade of studying it, it cannot be fixed by legislative means, because there's no reason to anticipate that a judge will reply and respect a new legislation any more than they have for the last 4 decades existing legislation. What I've seen today is a condescending attitude by those empowered to run this machine. What I've heard, for example, with the person who brought a Slurpee to her mother, that's an allegation that there was something wrong with the Slurpee. Was it tested, or was that allegation enough to convince the investigator that there was a serious problem in order to take away the rights of visitation of an individual who has rights? There's a problem, and I personally think that guardianship cannot be fixed. It has to be abolished and replaced with something much more humane and much more just. The system as it exists today is asymmetric. There is an enormous discrepancy between the power of the people in charge and the people they're in charge of. And until we address that basic problem that has to do with ageism, discrimination, and abuse of power, these discussions occur in a vacuum. I encourage the task force to go forward, even though I've noted in my written remarks that there have been a lot of other task forces in Florida that all failed. I encourage you to continue your work and offer whatever assistance any of us can give you to accomplish your task of fixing or abolishing guardianship. Thank you for the opportunity.
Thanks, Sam.
Dr. Sugar, I know you've been at this a long time. I've heard you testify before legislative committees. Our next meeting is going to focus on what other states are doing to address guardianships. And you may not agree with me on this, but there has to be some type of structure for a person who becomes incompetent. And if there is a better structure that you can come up with or you have studied and can submit, well, it probably is not going to happen in this legislative session, but this group can at least, look at that and maybe take on the cause. You'll win some allies there.
I would hope we'd be able to discuss that. I'm certainly happy to do so. There are some initiatives, including those of Judge Morley, that I'm very, very familiar with, which is elder caring coordination. But perhaps we could have that discussion, and I'd be happy to.
Thank you.
Thank you. Thank you.
Sue Melendez, our next speaker. You're now recognized, Sue.
Ken, I also just want to remind everyone, if you will, if you're joining us via Webex, you can use the raise your hand feature, and I can call on you in that order. And we also have a request by Rick Black to speak, Ken.
Okay. Am I calling people in the right order, Sarah? I don't want to cause a problem here.
No, I think we can take Susan, and then we can go to Mr. Black.
Okay, go ahead. Susan, Sue. Sue, you have to unmute or something. While we're waiting for Susan.
Can you hear me?
Go ahead.
Can you hear me?
Yes, we can now. Sue,
Good afternoon, Ken and the task force. Thank you for the opportunity to offer some insight from my perspective. We had a meeting earlier this week with Ken's office and his staff and a group of guardian advocates. And I agree with Sam that I think the system is so broken that it does need to be abolished. One of the recommendations that we made as a group that we want to discuss and research further is a program that would give an attorney or a guardian advocate access to a potential ward from the onset of a case. And that person, I mean, Florida statute talks about what's in the person's best interest, but we see time and time again that people have a conflict of interest, that they're not working in the ward's best interest, and then we're talking about, you know, how to mitigate all those problems after the fact. This would be a program and a solution to stave these concerns and issues off at the pass. There should be a federal or a state allocation and funds available for these attorneys that they would represent the potential ward, keep their rights intact, recognize their advance directives and their healthcare surrogate. And I have drafted an affidavit that would follow the individual throughout the process, that if they need help with their physical well-being, if they need help with advance directives or documents that are not part of their current estate plan, that the attorney would simply put those things into place, and that we would not look to the probate court system to deal with people that have alcoholism, drug addiction, and family conflict. So many times you could have Mother Teresa taking care of a mother or a father, and all it takes is one adverse sibling, and we have family conflict, and the advance directives get thrown out. And that's not fair to the people that work their entire life, that put those things in place for how they wanted to age gracefully. And so I would advocate for a program that would involve the attorney to represent the potential ward and avoid this complete debacle.
Thank you, Sue. And Sue,
Thank you, Ken.
Sue, you didn't even use all your time. I'm amazed. I've known Sue before we got into the guardianship thing. So I say
And
that lovingly.
I put it in writing. I put it in writing, Ken. So you also have a copy that I submitted through the online portal.
Thank you.
Thank you.
Mr. Black, you're recognized.
Can you hear me, Ken?
Yes.
Yeah, I'm still hearing Sue Melende.
Well, we don't. We just hear you, sir.
We can hear you beautifully, Rick. Clearly, nothing else but you.
I'm hearing Ken have a discussion with Sue. I can't deal with this. I'm listening to Sue Melende.
But we can hear you without anything else in the background.
Okay, I'll give it a shot.
I think it may be because he has the YouTube on at the same time, which is a little bit delayed.
Did you hear
Okay, Sarah, are you with me?
Yes, sir. If you want to go
Okay,
ahead, I think there's a delay with the YouTube.
No, you're the best, Sarah. Thanks for the education. My apologies to everyone.
No problem.
I didn't realize I had both screens open. I just want to highlight some numbers, which I think are rather critical, and I want to thank Jenna Murphy, Shannon Miller for her comments, and certainly Anthony for what the team put together to present to the public. Your estimate, which is the first time it's ever been estimated, that there's roughly $1 billion under the control of guardianships in Palm Beach County. I appreciate the transparency. That means that there's approximately 15 billion with a B, bravo, across Florida that are managed by this system and really only have one person who is responsible to make sure these people are protected as well as their assets, and that's the judge who sits up on the bench. All the testimony indicates the system is broken. You're handling this manually. I managed hundreds of people in my career, did a full-time job, raised a family, and had to check expense accounts on just a couple of $1 million a year on maybe 15 to 20 employees at any one time. I could have never done that without a digitized system, a system that forced everybody to file their expenses, to file their credit card statements, to file their receipts, so that the system did 90% of the work. And I just had to look for exceptions, red flags. And as we talked about in the last meeting, this is all about exceptions. $15 billion in assets across the state. There have been 0 convictions through the process by which this court has chosen to punish, if you will, professional guardians. That's the Florida Department of Administrative Hearings. Not 1 conviction in the last 20 years. 2 criminal convictions of professional guardians in the state in the last 15 years, and that was done completely separate of the court who sponsored them. So again, it indicates that you can't handle the bulk of the reality in guardianship, and you definitely can't identify exceptions and address them, even criminal activity within your system. So I love Ms. Miller's comment. This needs to be handled by law enforcement and legitimate investigators who are completely outside of the jurisdiction of the probate court system. Secondly, you ought to be using a digital system. These systems are inexpensive to install nationwide. Minnesota has installed one. Pennsylvania has installed one. Other states have installed them. If Florida truly wants to be best in class to protect their vulnerable adults, then upgrade your systems, take the manual issues out of it, and really make it a best in class system. Thank you.
Thank you, Mr. Black. Thanks for being with us today. Craig Schaefer, you're recognized. Mr. Schaefer, are you still with us?
I think that may have been one of the written comments.
Okay, and how about Kenneth Marcantino? I just butchered your name, sir.
And Ken, next is actually Karen.
Oh, Karen Burling. Okay, Karen Burling, you're recognized.
Let me see how to. Hello?
Yeah, we can hear you, Ms. Burling. Go ahead.
Hi. I just wanted to add, there is a lot of background here. Yes.
And how about
Karen? This is my opportunity?
Yes, ma'am.
Yes. Yes. I just wanted to comment that
We can hear you perfectly, Karen.
I was the individual that Jenna Murphy commented about a guardian and her selling Ward's personal property. I was the one that submitted that complaint. And basically what happened is nobody here really knows how much cash was generated at that sale. There was, okay, there was, okay, anyway, so okay, here's the point. Nobody knows how much was generated in the sale. There was no court order for that guardian to sell that person's belongings. The guardian's husband was conducting the sale. And the bottom line here is that she got a slap on the wrist. and that's ridiculous.
Thank you, Ms. Burley. And we're sorry our connection wasn't better. Steve Hitchcock, you're now recognized.
Thank you, Mr. Burke. And I appreciate the opportunity to speak with you all today. Can you hear me?
Clearly.
Thank you. And again, I appreciate the opportunity to speak with you all today. And appreciate the members of this task force. I've worked with many of you over the years on various projects, been in front of you as an attorney. For those of you who don't know me, I am a guardianship attorney. I represent professional guardians. I represent many families. I represent individuals in guardian advocacies, and I also serve as a court-appointed attorney representing alleged incapacitated people, getting them through that process. I will keep my comments related to today's subject matter, again, I appreciate the opportunity. With regard to the auditing system that OPPG and the Clerks Association has entered into, my comments are primarily that clerks, certified clerk auditors are certainly qualified, excuse me, to audit financial issues. But I would submit that clerks and the auditors are not particularly qualified to assess personal issues, such as whether or not proper physical care has been maintained for the ward, whether the ward has been isolated from family members and things of that nature. That analysis would be better suited to other professionals, other licensed and trained professionals, such as licensed social workers, nurse care managers, and the like. And I also feel that the new concept of elder caring coordination should be analyzed as part of this process. I was very, very happy to work with Judge Morley and Anthony Palmieri and several others in developing the elder caring coordination legislation that was passed last year. Kudos to Judge Morley on getting that passed. And I submit that elder caring coordinators and other licensed and trained professionals are better suited to deal with the personal issues with relation to guardians and their guardians, wards, and their families, rather than financial auditors. And I appreciate the opportunity to speak to you all today. Thank you.
Thank you, Steve. Appreciate you being with us. Gina Rossi, you're now recognized.
Hey, thanks, Ken. I just wanted to make a brief comment. I was very happy to see the statistics that Inspector Palmieri brought before the group today. I wish I had had a little more time with them so that I could comb over them. I do have to say that I am in disagreement with folks that believe the guardianship system is a broken system from start to finish. And when I look at what Inspector Palmieri presented today, with 86% of the allegations against guardians being unfounded and 13.2% being founded, I just don't think that indicates a broken system. Having said that, there isn't room for anybody to step out of line in guardianship. Excuse me. There isn't any room for anybody to step out of line in guardianship. And those issues absolutely have to be addressed. I want to echo what my colleague Shannon said, because as everybody was talking, I was taking notes. Court monitoring, more education, and more training were some solutions that came to mind, as opposed to actually having legislative solutions, which also might be necessary. I'm not sure. I'm sure this group will talk about it and will come to some good solutions. The Florida State Guardianship Association supports raising educational requirements for guardians and also specializing those hours. I think education and training is an issue and monitoring is an issue. There are thousands of individuals with severe disabilities that are protected and served by professional guardians and family guardians in this state. Many of those individuals do not have one other person in the world looking after them. So while there are problems that have to be addressed, and I'm so glad the group is together to look at that, to look at Florida's system and say it's broken from start to finish, just have to take a moment to express my disagreement with that. Glad to be here. I'm glad for what's presented today and all the perspectives. Thanks for having me in the group.
Thank you, Gina, and we're pleased to have you as part of this group. Thank you for serving on the task force. We certainly appreciate everyone's participation today. Anthony and your panel, thank you for presenting. We have a hard stop at 2 o'clock, which we are rapidly approaching. Other ideas, Hillary suggested an idea for a future meeting. The good judge, who's our special advisor, maybe we need to hear from her on a future meeting as far as her views, since she studied this so much. Shannon, do you have an idea for us?
I do. I would like to offer a court-appointed attorney to come in and just talk for maybe 5 minutes and field questions, because I know that's been a real concern. And I do have a court-appointed attorney in our circuit who has expressed willingness to come in and talk about her process and what she does. And then the second thing that I'm still trying to find a family guardian who's not a professional, who might be willing to talk about their experience as a family guardian. And I think that could be really instructive to this panel. But I don't have a person in mind, but I do think that that might bring another aspect to this process that we might be missing otherwise.
Good. And we're taking good notes of today's conversation, so we'll make sure we add those to the list and those. And Judge Morley, would you be willing to present in the future meeting? Putting you on the spot here.
Sure.
Okay, well, I think that would be good too. I know you're progressive in this area, so it would be good to hear from you. Next meeting, I'm very excited that we're going to have Tom Hall and Kimberly present to us on a compilation from other states, what they're doing as far as legislative activity that advances the cause of the ward. And maybe we even want to look at the terminology and see if that could be changed, because that seems to have some pejorative content now. But that's something if you have any state which you've heard of good things coming out of, please email us and we'll add those to taking a look at. We're doing our best to try to get as much of progressive activity as possible from around the country. So yes, Hillary.
And again, I just like to say thank you for this obligation that I was given by you to speak on behalf of the wards. And I just very quickly like to end with, for me, a situation of 2 wards, Chinite Jersey in I'll be quick, in Pinellas County, and Alice Yanisavich in Manatee County. Both of them were in guardianship and they died of COVID-19 alone, isolated in hospitals. Both of their families motioned the court, emergency motions, to release them from guardianship. They would wear ankle bracelets like a prisoner, but they needed to go back home. The money was given to the guardian. Both times the guardian and the judge refused. And these 2 people died in guardianship without committing a crime. The other side of the state, Anthony Palmieri's County, Linrod Douglas was in jail awaiting his trial for the crimes that he committed in guardianship, exploitation, theft, perjury. His attorney petitioned to get him out and he was freed. And it's just, who do we care more about? The guardians, the for-profit guardians, or the wards? And that is what we are supposed to be speaking about here, is them and these innocent people that have never committed a crime, and not about, giving the guardians more of an hourly wage or whatever. But it really, really infuriates me about what is going on in the guardianship system. And if even there's one bad guardian, that is too many. And thank you, everyone.
Thank you, Hillary. Again, I want to say thank you for everyone's participation today. Our next meeting, I think, is scheduled 2 weeks from today. And again, that will be on the topic of progressive legislation across this country. We have the opportunity as task force members to communicate with each other between meetings. This is not a sunshine body, so we can do that. So any recommendations you have, please pass them along. I want to end the meeting by thanking Sarah Sanders Brenner. Sarah has been part of the Clerks Association for 13 years. She's been one of our staff people assigned to this committee. She's moving on to greener pastures. Really, she's moving on to orange and blue pastures. She's going to work in government relations for the University of Florida. So Shannon, in your area there, but she's staying in Tallahassee to do that. So Sarah, thank you for staffing our committee here, and we wish you the best with the University of Florida.
Thanks, Sarah.
Thank you, Ken, so much.
Bye-bye,
Kimberly
everyone.
will serve you all.
Thanks,
well.
everyone.
Bye-bye.